Okay, everyone, now we're gonna have this, what is it, Gremban matter, so you're all set, you all can stay on, so we can call this matter. We do ask, we're gonna get started in just a moment, everyone. Our way down where your device is muted until your case is called, okay? Once your case is called, we'll ask that you would unmute, turn your video feed on, state your name and how you're related to the matter. After the hearings, if you have any questions, please contact your attorney. If you do not have an attorney, you may email the courtroom with your questions, but just keep in mind that legal advice cannot be offered, okay? Again, thank you all for your patience, and we'll get started shortly, okay? And let me ask for the Gremban matter, who all do we have present?
My name is Kaylin Wilson. I'm here for Father Adam Gremban, who's appearing via Zoom.
Okay.
Judy Coleman, I represent the petitioner in this matter, who is Samantha Smith, also known as Samantha Lovett, who is appearing via Zoom.
Okay, perfect. Okay, thank you all.
Also, I am here for Laren Graham. I don't know if she's, I thought the court hearing was for 9:15, but it might be at 10 o'clock.
What's the name? Leonard?
Last name is Graham.
Larry Graham, yeah, we have it at 10:15.
Okay, thank you.
You're welcome. Excuse me. Okay, thank you. Hi, Miss Goddard. What case are you here for? Marissa Goddard, can you hear the court? Marissa Goddard, can you hear the court? Miss Hart, we're actually going to call, the cross matter first, okay?
Okay, thank you.
The Wayne County Probate Court is now in session. Honorable Judge Karen Keith presiding. Calling the matter of Javon Cross.
Good morning, Your Honor. For the record, Brandy Hart, the successor petitioner in this matter.
Thank you, Ms. Hart. Does anyone else appear on the matter of Cross? Okay. Ms. Hart, this is a petition to modify or to terminate.
To terminate, Your Honor, I was initially appointed the special fiduciary back in 2019 due to the suspension of the mother of Javon Cross. She was suspended for failing to file an annual account. Your Honor, I have diligently tried to locate the funds that were received for the minor from a personal injury settlement. Nothing in the file indicated where the funds were deposited. There was only an inventory that was filed that indicated a gross settlement of $17,500. I reviewed the GAL report and discovered that from the settlement, the minor netted approximately $10,700. I sent out correspondence to the prior fiduciary. I also sent out correspondence to the attorney of record in the file. The attorney indicated to me that he's no longer with the firm where the case was settled. So, Your Honor, I have spent funds trying to locate. We also don't have a proof of restricted account on file so that I can actually file a lawsuit against the bank. So, Your Honor, I'm looking to terminate this file. Mr. Cross is now 20 years of age. I have not had any contact with him or his mother. I'm at a dead end, Your Honor.
Petition is granted for the reasons stated.
Thank you, Your Honor.
You're welcome. Services is terminated. You're all set. Sorry. All right.
Calling the matters of Oliver and Lim Gremban.
Good morning, Your Honor. Judy Coleman representing the petitioner this morning.
Okay, hold on. Ms. Coleman, I'm having.
I'm sorry, Judge.
Let's try it again.
Judy Coleman representing the petitioner, Samantha Smith, Samantha Lovett.
I'm sorry, Ms. Coleman, I'm getting this reverb echo. Both on when you speak and when I speak, I can hear it coming back to me.
I have no idea why I have no other devices on, Judge.
Hold on just a moment. Okay. Say that again, Ms. Coleman.
You're not having.
Judy Coleman represents Samantha Smith, also known as Samantha Lovett, who's the petitioner today.
Hey, I don't know what happened, but you sound a lot better right now. Thank you. Okay. Who else is appearing on this matter, please?
Good morning, Your Honor. Kaylin Wilson on behalf of respondent father Adam Gremban, who's appearing via Zoom.
Great. Thank you. And do we have anyone else present on this matter, please?
The petitioner is here. Identify yourself, please, Miss Lovett Smith.
I am Samantha Smith, and this is my husband, Cody Smith.
Right. Thank you. This is a petition for guardianship. Ms. Coleman, from having spoken to counsel last week, there was she believed that there may have been a conflict, misunderstanding about the date for the actual hearing. And I made a determination at that time, one, to make certain in light of the conversation that Ms. Wilson has stated, she has shared with you, to make certain that you had your opportunity to appear before the court and make your argument, so as not to have Ms. Wilson appear to be less than trustworthy on her words about the conversation between the two of you. This was a petition, your petition for guardianship, for which objections were filed, and ultimately the response to the objection that is cogent to persuade the court to rule otherwise.
Well, first of all, Judge, I apologize. I'm not sure what happened. This, as far as I knew, was always scheduled for today.
No problem, Ms. Coleman. I no offense, no problem with that. It happens. Go ahead.
Okay. I just have several things that I noticed that Ms. Wilson has omitted from her objections. Number one is she has not addressed the fact that there needs to be a custody order to move these children more than 100 miles from their established custodial environment, which is Michigan. Mr. Gremban lives in Brooklyn, New York, and has resided there for some time. These children have had very little contact with their dad. He has maybe visited them a couple of times in the last couple of years. I discussed on many occasions with Miss Wilson how to establish some parenting time in the interim, and we couldn't seem to get Mr. Gremban in to confirm that he was even going to be in the state. And the children, one of the children, Liam, has he is actually autistic. So the established custodial environment is extremely expensive, or is extremely important, because he is used to it, and uprooting him and moving him without any kind of a plan in place is going to be very detrimental to him. The other thing is that Ms. Wilson addressed the fact that Mr. Gremban was never aware that the children were residing with people other than the custodial parent who was unfortunately who died. And the issue there is that he states in his own objections that he was aware that the grandparent lived with them, and so did Mrs. Smith, Mrs. Lovett, the petitioner, up until perhaps 6 months ago. That was her permanent residence. So they were all living in the same house and had been for many years. The children are 8 and 6, and I have heard nothing from opposing counsel about grievance counseling, or not grievance counseling, grief counseling. I haven't heard anything about what they're going to do to keep the continuity in place for Liam, the child that's autistic. He is seeing a person addressing the autism 5 days a week. And their plan, from what I understand, is to just take the children, move them to Brooklyn, New York. They haven't addressed the fact that there's a child support arrearage. I've asked about it. It belongs to an estate. If there is an estate opened, which I don't believe there has been one yet, but there will be if we have assets. And Judge, there's just a lot of things in this situation that are not being addressed in a transparent manner. The pictures that are submitted, we had asked originally that pictures of the home where the children were going to reside in Michigan be submitted. Those pictures are pictures of a home in Brooklyn, New York. These children have had very little contact with their parent. And the first contact that he made with them in Michigan was to show up at 10:30 p.m. the night before their mother's funeral without any announcement that he was going to do this with the police department. And our issue was we had been in contact with him. I had been in contact with him. Miss Smith Lovett had been in contact with him. We had told him, just arrange something. We'll figure it out. We want continuity for these children. And he simply showed up without any notice with the police at 10:30 before their mother's funeral. It was just such a bad parenting decision that we felt that we really needed to push for this guardianship so that there could be some sort of transition plan or some sort of continuity of care for this child.
Okay. Anything else, Ms. Coleman?
I do not believe so.
All right. Ms. Wilson, your response to Ms. Coleman's points.
Your Honor, I think a lot of the points that Ms. Coleman raised will be dealt with in hearing in the family law case, which is actually tomorrow morning. I think she raised the custody issue in the family law case, which said she would deal with after we had some sort of decision in this matter. The pictures that were provided attached to my objections are both the home in Michigan and the home in Brooklyn to show both where the children would be residing. I don't think that the established custodial environment is with a place, it's with a person, and that was with mother, who has now passed. My client has joint legal custody. The MCL 700.5204 is very clear that in order for petitioner to have standing, my client had to permit his children to reside with another person. He did not allow these kids to reside with petitioners. He allowed them to reside with their mother. When he became aware that she passed, he instantly arranged for his job to give him time off in New York. He got up to Michigan as soon as possible to pick up these children. They refused and would not turn over the children. They continued to refuse to turn over the children to him. They then filed the custody case, which he fought in the custody case to have the children returned to him, and said that they don't have standing to bring a third-party custody case either. All of the other things, I agree, my client's going to need to make some arrangements for things for these children, their schooling, their doctor's appointments, all of those things. That is not what's required to appoint guardians to these children. They are hanging their hat that my client allowed these kids to reside with petitioner. That is not true. At the time that mother passed, as Ms. Coleman just stated, the petitioners were not residing there and had not resided there for 6 months. Had grandparents been the one to bring this case, maybe there would be some different argument, but there's not. So my request of this court is to deny the guardianship and to have these children turned over to my client. We'll deal with the custody issues, the established custodial environment, the child support arrearage, and everything else in front of the family court, which is the proper place to make these arguments.
Anything else with regards to Ms. Coleman's statements?
Nothing else, Your Honor, at this time. Thank you. I think my objections speak for themselves.
The court is going to set aside its ruling from last week, grant a petition for guardianship. Based on the points that are raised by Ms. Coleman, the primary concern in a petition for guardianship is the welfare of the minor children, in this case, minor children, more so than the interest of the parent or the adult seeking who has custody, biological parent involved in the case or the interested parties in the case. The court's attention must be focused on the interest of the children. What I did not hear in your response, Ms. Coleman, Ms. Wilson, is in particular concerns about Lino being an autistic child. Ms. Coleman stated the amount of time that he is receiving, he's being seen. We won't bother to get into all the particular needs and delicacies of dealing with children who are autistic, but it would be highly inappropriate and disruptive to an autistic child to move him or her from an environment that they are accustomed with, that they are balanced with, that they have their senses about, and to take them abruptly into a new environment. That's uppermost in this court's concern, that yes, they can be dealt with over time, but it requires the court being presented with evidence of what the plan, what the approach is going to be, reports from the doctors as to whether or not that particular child with his or her unique circumstances can accept or must be aware of various changes in the environment. Just as simple as the lighting environment can be crucial to a child who has autism. Those issues that Ms. Coleman raised have not been addressed in your response to her statements this morning. You didn't also, to the court's satisfaction, explain the response that Ms. Coleman made with regards to the appearance at around the funeral. Granted, we have 8 and 6-year-old kids, but they're still very perceptive and impactful of what happens with their mother and with people around them. So at this time, the court's going to grant a temporary guardianship. The court is also going to provide for Orchard Children's Services to come out and do a further investigation and come back, give you a further recommendation on that. We'll go from there. That will allow you to go into family court, make your case, and see where things go from there. We'll be back here. Looks like I'm looking at July 25th at 10:15 as a follow-up. Anything else, Ms. Wilson or Ms. Coleman?
No, thank you, Judge.
Nothing from me, Your Honor. Thank you.
Let's see, I want to make certain we have, Ms. Coleman, we need your client's AOA, acceptance of appointment.
Yes.
Okay, if you will have them sign it and email it directly back to my courtroom, we'll be able to email to your attention the letters of authority. All right?
Thank you, Judge.
Thank you, everyone. That concludes your hearing. You can disconnect.
Thank you.
All right, guys. Well, I'm gonna jump on here real quick. So I'm in the car, obviously. So obviously we just heard what obviously just happened at this hearing. A couple of things. At the last hearing, one of my concerns, Dad was actually granted his petition, his objection was granted by the judge, because what occurred was the attorney and the respondents weren't present. So the judge did basically award him guardianship over the kids. Dad's attorney raised some concerns because what occurred is they had two separate hearings, one for each child, and Dad's attorney ended up raising some concerns about this hearing this week, at which point basically the judge halted his order and combined both hearings for this following week. I think part of the strategy was thinking that, well, since he kind of ruled in their favor, that this week for the second child he would rule in his favor. I raised immediate concern last week, regarding that, because you always want to get an order actually granted and put in, because it just makes it a little more difficult to kind of overturn an order that comes through. And my concern was exactly this, was if the attorney wasn't there, there may be an opportunity that this hearing some things may come up, and that's what seems to have occurred. So unfortunately, that didn't go in Dad's favor here. But just wanted, I took a couple of notes because I think there was some really key bits of information that came across here. First of all, when we talk about our rights, or when we talk about kind of what should be expected or how things should go, we have to realize that what we think is right outside the courtroom hardly ever translates to what is right inside the courtroom. And the reason being is because the courtroom operates at a whole different process, operate at a whole different level, and they themselves have certain statutes and so forth that they need to take into account. In addition to, they want to make sure that they always err in the caution of the child or in the safety of the child. We always hear, we talk about this all the time, the best interest of the child, right? I mean, it comes up time and time again. Absolutely, it was going to come up here. So just a couple of things with that. Right off the bat, we can see the title here, and we say, well, hey, the child dies, or the mother dies, dad should automatically get custody. In theory, that is true. But then we got to apply the logic of the courts and the process and how they're going to come at this. Absolutely. If the kids, well, a couple of things. Having a plan, having a parenting plan. We talk about it in the group all the time, right? We can't just say, well, I want custody of the kids. I deserve the kids. I'll figure it out. That's not going to fly. It didn't fly here, right? That is not going to fly in court, right? The courts are going to require, even if it's just so that they can say they did their due diligence, the court is going to require some type of a game plan, especially if there's a medical condition with one of the kids. If he has autism, you're gonna have to have a game plan. You're gonna have to have names of doctors, an actual, a report, recommendations, where he's gonna go, what's going to happen. Not necessarily also just to satisfy the court per se, but you kind of need a game plan overall, right? I mean, we have to see it through. We can't just stop at, well, it's my right to have these kids. Of course it is. Of course it is. But we live in a society and we live in a jurisdiction that there are certain processes that have to be followed before that's brought over. Doesn't mean it's right. In this case, listen, of course, dad can just get them. Those are his kids. Let him go and he can figure it out. The kids will be fine. And we know that, right? We know that, a parent will figure it out. It's why you're a parent. It's never easy. We know that. But we have to play the game. We have to put on the show. So, and I could go a little way deeper into that. I won't, just because of, I guess, the openness of this particular group. But in the sense of those that may be on here, because we have this on the public page and on YouTube as well. But we just have to be able to satisfy the requirements as required by statute. We have to create the path for judges to come over to our side, even if we don't agree with it. It's just kind of what we have to do. So his attorney, I think, raised the NCL statute pretty well. I think she spoke about that. I think she did make some kind of headway there. I think it kind of just it always kind of falls apart because it comes around the children's best interest. We see this all the time. And that's the tricky part. So anyway, just wanted to hop on here real quick and reference that. I wasn't prepared to do a live, as you all can see. I'm just kind of just in the car taking care of some things, but I will see about getting the info for tomorrow's hearing, see how that goes, and see how his attorney kind of regroups and puts her stuff together. All right, guys. Hopefully you guys got some information out of this live today, and I'll see you all tomorrow. All right, thanks.